Code enforcement officers, you ready? Okay, then I'll call us to order. We'll start off with the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And anybody who's going to offer testimony today, if you'll stay standing, I'll go ahead and swear you in. So I'll swear from the testimony you give today is the truth, the whole truth, and nothing but the truth. Swear. Thank you. And for our one respondent, my name is Drew Smith. I am the Code Enforcement Special Magistrate. I am not an employee of the City of St. Cloud. I am a private practice attorney. My role in these proceedings is to be an independent trier of fact. Speaking of the city's counsel earlier, I suspect he probably told you how it's going to go, but they will present their case first. When they're done, you have the opportunity to ask them questions and also to present to me any evidence testimony you'd like me to hear. When I've collected all the evidence testimony, then I'll enter a verbal ruling today, and that will be followed in the mail by a written ruling she'll receive. Okay? And did you get to review everything you wanted to review?
I did.
I'll go ahead and take your case first if you're okay with that, so we can get you out of here.
I see it's a packed house.
Yeah.
So.
Case number 2024-915, Dustin Riley, John Patton, owner, Emily Dykstra, owner, location of violation 1422 Florida Avenue, St. Cloud, Florida.
Good afternoon, Pam Neal, City of St. Cloud Code Enforcement Officer. I am presenting this case for the property located at 1422 Florida Avenue. At this time, I would like to enter into evidence the following items: copy of the notice violation sent to the owner, copy of the notice violation sent by certified mail to the owner, copy of the notice violation with the new date sent to the owner, copy of the statement of violation notice of hearing sent by certified mail to the owner and posted on the property in City Hall, a copy of the corrected statement of violation and notice of hearing sent by certified mail to the owner and posted on the property and City Hall. Copy of the statement of violation notice of hearing with the new date sent by regular mail to the owner and posted on the property and City Hall. Copy of the affidavits of postings, copy of the PowerPoint presentation, evidence of mailings, copy of the deed to the property, a copy of the code sections in violation, copy of the costs incurred if the special magistrate finds the respondent in violation in the amount of $298.69. Respondent is here and he has received a copy of the evidence.
Thank you.
On May 28th, 2024, while checking on a complaint in the area, I noticed a gray truck parked in the alley that is inoperable and has no tag. I took 2 photos. On June 4th, a reinspection was performed and the truck was still there in violation. I took 2 more photos. On June 5th, a notice violation was sent to the owner. On June 14th, the reinspection was performed and the truck was still in violation. And I noticed an above-ground pool was installed in the rear yard with no permit. And I took 1 photo. On June 17th, a notice violation was sent by certified mail to the owner. On June 20th, I went back to the property and took a photo of the pool. And I took 1 photo. On June 28th, the reinspection was performed and the truck was still in violation and there was still no permit for the above ground pool. I took 2 photos. On July 1st, a notice violation with the new date was sent to the owner. On July 12th, a reinspection was performed and the truck was still in violation and there was still no permit for the above ground pool, and I took 3 photos. On July 15th, a statement of violation notice of hearing was sent by certified mail to the owner and posted on the property in City Hall. An affidavit of posting was completed. I took 4 photos. On July 30th, a corrected statement of violation notice of hearing was sent by certified mail to the owner and posted on the property in City Hall. An affidavit of posting was completed, and I took 1 photo. On July 30th, I talked to the owner, and he stated that he is now in compliance. On July 31st, a reinspection was performed, and the truck was gone and the pool was removed. It is the city's recommendation that the respondent be found in violation of allowing an abandoned vehicle and an above-ground pool to be installed prior to obtaining a permit at this location. The city would like to also recover the costs incurred in bringing this case before the special magistrate in the amount of $298.69 to be paid within 7 days of the written order of the magistrate as well. And that concludes my presentation.
I have no questions for you at this time.
Okay.
Respondent?
Yes.
Maybe you just start off by stating your name and your relationship to the property for me, please.
Absolutely. My name is Dustin Riley John Patton. I am the owner of the property. How would I address you, sir?
You can call me Mr. Magistrate, Mr. Smith. You can call me whatever
Okay.
you like. Nobody's ever asked that question before. You throw
Well,
me
no,
there.
I don't know because
I'm not, I'm
know.
not truly a Your Honor. Lots of people, but I'm not truly a Your Honor, so you don't have to call me Your Honor.
I just didn't want to misname. That's all.
No worries. Thank you.
So I do have a question on this. As we can see in the photos that she has actually supplied, you can see that the pool itself did have water in it at one point, which is a temporary pool with no plumbing or attachment to electronic as well. Which when I look up the structures statement in building code, if there is no plumbing to the pool or no electronics going to the pool, temporary pools are allowed. You can see the date after the notice that I had received. The pool is now empty. It did take me time as I do respond to natural disasters doing roofing. I was not in the area. I have not been able to receive most of those certified mails. I was only able to sign for one. So when I did find out notice, it was one time and then my yard was posted. There was also a correction to that posting in which was done on the 30th. On the 30th, I was up to code. I was actually code up to the day after her second photos that had the physical posting. As my neighbor let me know, I was posting my yard, not following code compliance. I fixed, sorry, not erected, all of those items. No photos were also taken on the 30th, except for the second posting, which is a correction for the actual date, which would show my magistrate date. I don't know what the correction was that needed to be posted twice. I would like to know what that is, because on the second posting, all things were up to code, and I'm not quite sure why it had to go to a magistrate. I called multiple times to code enforcement for clarification on pools and permitting before its use for a recreational event for one day. I was unanswered. And when I was,
Sorry, say that last part again.
I was unanswered
No,
to
the
phone
part
calls.
before that, the one day.
Yeah, the pool is actually only in use for one day. So it was put up, has no filter, no nothing. I put water in it. It was used for a party, and then it was drained. Unfortunately, I was unable to do that the one day prior to when she came back for her reinspection, but the day after, everything was fixed.
When was the pool removed?
The pool has been removed since the day after that photo of it being out. It took time to obviously drain the pool. I can tell you the exact date. Give me 2 seconds. You can see photo CE number 24/9/15, date 7/15/24.
So is it your testimony that the pool was brought into compliance on July 15th of 24?
Yes. Yes, that photo was taken earlier in the day.
And the truck was
Unfortunately, I
removed
worked.
on what day?
It was removed on that day, the 15th, sir.
Okay, so both removed on the 15th.
The vehicle itself is also, to get to the vehicle, it is operable. I know it does not look very pretty, but it is operable and does have a tag, and I can add that tag into evidence.
Was the tag on the vehicle?
The tag has been removed from the vehicle because I have had tags stolen off of my property multiple times. I also have DMV records showing each time I have had a plate stolen, which is why that plate being a dealer tag is removed.
So that you understand, as the city of St. Cloud's code is written, if the tag is not on the vehicle,
Correct.
it is not, it cannot be driven on the road, and it will be treated as an abandoned vehicle.
Absolutely. I do also know that it states that it needs to be on the same parcel for that duration. It was actually on 2 separate land parcels that are not owned by myself, one being a city space, which you're allowed parking, which is the first photos at the back of the property.
You're about to make an argument that's going to annoy me.
Oh, I'm sorry.
If you're going to argue that it wasn't on my property, it was on the right of way, you're going to frustrate me.
Not
Don't
trying to
make that
frustrate you.
argument. I understand. That's why I'm
appreciate it.
intervening and saying, don't make that argument.
It was
It's
not
going
my-
to sway me. It's going to frustrate me.
You're good. It was not my main, obviously. I just do want to show
Yeah, I
that
know.
those photos were also taken in separate locations, showing that the vehicle is operable, moving, and I have no problem proving that.
But again, by code, this was not an operable vehicle at the time. I was observed by code enforcement.
It did not have a plate on it, so if that's what needs to be operable, you are correct.
Yes.
which I can agree to.
And again, I'm not asking you to agree to anything. I'm just making sure as you go forward that you
Yeah.
don't fall into the same
Yeah.
position again.
No worries. Definitely not a lawyer or anything like that. Just trying to give all the information.
Go
I
back
can.
to your building code in the pool.
Yes. So
What's
when
the exception?
so it says that there are pools that don't have anything that are temporary.
Do you have the text of the building code for me?
I do not. I can
Do you have
get
a
that
section
there for
number?
you. Give me 2 seconds. Am I allowed to use an electronic device?
Yeah, absolutely. Go
Okay.
ahead. I'm about to do the same thing. That's why I'm
Sorry.
asking for the section number.
Yep. No, when I looked up structures, it specifically stated that it needed to be plumbing, electrical, and temporary things were allowed. And all of this is obviously extra to the fact of my original question, which is to why I was posted twice. And on the date of the 30th, no photos were taken of the truck not being there or the pool being down, even though everything was on compliance on the date of posting. I apologize. I thought I had it on a save tab, and I
okay.
do not.
Part of the reason why I want to look at what section you're looking at, one, I want to see the text for myself, obviously, but there are multiple sections of building code, and the exception you're talking about sounds to me as if it may be an electric permit. I mean,
Okay.
you sound like you're in contracting, so I expect you're familiar with building code.
I'm
So
familiar
you know
with
there's
building
multiple
code.
sections. There's electrical,
Yeah,
there's plumbing,
right.
and so it would make sense to me that you do not have to have an electrical or plumbing permit if you have no electricity or plumbing. So if that
Right.
exception was in those sections, that makes sense.
Right.
But there are building code requirements for securing a pool.
Which
So
would be
I'm skeptical if there is a general exception for pools.
right. No, I don't think it's a general exception. I just was unable to find a pool that does not hook up to electricity or plumbing and is above ground, as it does not need those fences.
I see.
I see nothing.
But
strictly
even if
going
it's
on it.
above ground, it still has to be secured from unauthorized entry. And with an above ground pool, what Florida Building Code allows is you can take the means of access. I think if it's 48 inches high, it's 4 feet high, you can take the means of access, the ladder off,
Mhm.
in which case it is now compliant with that. But because there are standards for pools in building code, including above ground pools, I am skeptical that it is generally accepted from a building permit.
Oh, I don't disagree. I just cannot find a specific statement for. A
Oh, so
pool
you weren't saying
besides
that it was exempt. You just didn't see anywhere where it said, well, I will tell you this generally in Florida building code, anything that is vertical is a structure.
Okay.
And I'll tell you how I'm so confident about that. Technically, tree houses are structures.
Oh,
Nobody gets building permits for them though, but they are structures and they are code violations
treehouse-
if they're unpermitted.
Treehouse seems much more concerning, honestly. That's something that's up in the air,
but that's why I've researched it in the past, was trying to figure it out, because I know lots of jurisdictions. Somebody books up a kid's, builds their kid a treehouse. Nobody's going to say we're in your building permits. So that's why that was when I first how far does it go? And what I learned in that, basically in Florida building code, if it goes vertical, it's going to require a building permit.
Okay.
And the reason for that, and again, if you're in roofing, you know this, because anything that gets loose in a storm,
Yep.
it becomes a missile.
Oh, 100%.
Yeah.
Yeah, no, I asked for clarification and did call in multiple times. I have the records of the calls with no answers back, trying to access, hey, what needs a permit for a pool?
I've got my head around, I think, the violation. And let me ask the code enforcement. So
Absolutely. Let me step aside.
respondent is testifying that he was in compliance on 8/16, which looks to me as that would have been in compliance within the time allowed in your last notice of violation.
Let me look here. Let me address one thing. The reason I reposted it is because I had the time wrong on the statement of violation and notice of hearing. Yeah. So I'm trying to look here.
And while you're looking for that, for the benefit of the respondent, it's not uncommon here or elsewhere for there to be a repost or remailing of notice, and it usually is something like that. There's a technical thing, because as long as they gave you proper notice, they've met their burden. They've met their burden for due process. Really, if there is a mistake, if it's a notice of hearing and it gives you the wrong time, and that's in front of me, I'm ruling in your favor because you didn't know to be here at the right time. So that makes sense as to why they would have reposted, is that there was some technical error in the other, and so they were making sure that you got proper notice for the hearing.
When I went and posted it for the second time on July 30th, I didn't take any pictures on the July 30th time. And then to address another thing, I did try to call him back a few times with no answer. So,
As you know, the back and forth, I appreciate it when everybody's able to get together and work things out, but that doesn't influence my decision. What does, though, is was he in compliance within the time allowed in the notice of
No.
violation, or was he not?
just he was not in compliance when I posted it for the second time. But I did not take a picture. All I did was take a picture of
And
the
what are you
posting.
basing that statement on when you say he was not in compliance? He's saying he had taken the pool down and then removed the truck by 8/16.
by 8/16.
30th, I believe.
Oh, July
I
30th.
posted it that morning.
Uh,
So you have the 30th.
okay.
I'm trying to think. Okay.
Am I allowed to?
Come back. Yeah, you can come on back up.
So on July 30th, she was aware that I was in compliance. She did not take any photos because I was in compliance. She stated that on the
Okay.
phone.
I understand now. Now I understand. I had the dates. The dates were coming across. You were ordered to come into compliance by June 21st.
Correct. Everything was fixed by that date as well, but
Okay.
she had not come back to the property in between that time period. She
Okay.
came back to repost the property on July 30th, and the property was fixed. She even told me on the phone, I have a phone record at 2:08. She spoke with me on the 30th. I said, "Hi, I'm so sorry. I just missed you. I saw you in my front yard on my camera. I was inside my home." I have her on camera being there as well. I tried to contact her. She answered on the second call. And I said, "Hey, I just want to understand why you're reposting my property for code enforcement. What's going on?" She said, "Oh, the dates were wrong. It need to be reposted." And I said, "Okay, well, with that being stated, everything was up to compliance, correct?" She agreed. She even stated that in her beginning. I don't know what the term is for when you first start talking, but when she first started talking about this matter, she said that everything is in compliance. We had discussed it. That is the only date I have talked to her since, except in this courtroom, which would be July 30th.
Okay.
I do apologize that it wasn't done in a more timely fashion. Just so you know, I have no problem fixing things.
No,
but-
and that's really so. To help you understand, if code enforcement goes out and they see, because somebody who hasn't ever been in front of code enforcement, there's no reason why you would know this. If code enforcement goes out and sees a violation that has not been cured by the compliance date set the notice of violation, it is coming to me.
Yep.
Whether even though it may be in compliance as of that date, it's coming to me, because if it happens again, it's a repeat violation. So here and elsewhere, those cases go to the magistrate or the board, depending on which the city has. So it's not uncommon, nor is it something that they're being mean to you. If even though you've complied at some point, you still have to come to the hearing because it's for that finding
Absolutely.
of fact. But again, I'm still trying to understand. You're saying you were in compliance by the compliance date, and code enforcement is saying you're not. So let me get code enforcement back to the
Yeah,
podium.
no
and
worries.
say, what evidence do we have that he was not in compliance as of the compliance date?
I can't enter in video evidence that I was in compliance on those dates. I would just need to get it off my phone and given to you.
Okay.
So
let me ask code enforcement a
worries.
question.
When I went out there on the 30th, like I said, and posted the property, he was still in violation. I went out there
When you say he was
that
still in
morning.
tell me what was still in violation.
The vehicle and the pool. If I remember, I should have took pictures that day. All I did was take it of my posting. Because the last pictures I took was July 15th of the pool and the truck. And let me give you a little backstory on this property. It's
Right now, I just want the question answered. Was
Okay.
he in compliance as of the compliance date?
No, not on the very first statement of violation. and
No,
notice.
on the last statement of violation.
On the last one? No, when I checked it, when I posted that property, the morning of the 30th, he was not in compliance.
And what was out of compliance on the morning
The
of
truck
the 30th?
and the pool.
Where was the truck?
It was in the side yard, because the first time I seen it, The few times was in the back by the alley. So, and then he pulled it over there to the side. Or how, I don't know how he got to the side. It didn't look like it even had a radiator in it. So
And where was the pool?
in the backyard,
And you're sure?
I'm sure.
He's going to show me video evidence.
Okay.
Okay.
I can go down to my office and see if I got any other pictures.
If I could just ask a question from the inspector. Just in normal practice, when you visit the property, if there's a change in the condition of the property, you make it a point to take a photograph, do you not?
Yes.
Okay. Did you on this day?
On the 30th, I only took a picture of the posting because it was my second. He had already been scheduled. So it was my corrected statement of violation notice of hearing. That's the reason I only took it of the posting.
To your memory, had the condition of the property with the violations changed from the previous date you photographed the property on the 15th of July, on the date that you posted the property, July 30th?
No, it had not changed.
Can I ask Pam?
The date of your compliance from the notice, not when you posted the statement of notice.
Right. It was the first notice. The one that I,
I understand you send multiple notices, and I've
Okay.
commented on this before. The challenge of sending multiple notices, if you say in April you have 7 days to cure, but then you tell me again in June that I have 7 days to cure, it's the June notice that I'm going to look to. I'm always going to look to the last notice that
to
you
the
sent.
last notice, even though it was a statement of violation notice of hearing.
No, I'm talking about the notice of violation.
That was July 1st
Right,
was my last one that I had to post because he didn't sign.
right. So that's
for the
what I'm talking. That's what I'm talking about. Is I'm looking at July 1st and compliance with July 1st notice of violation.
Right. He was
And you're
not in
saying he did not comply with July 1st. That as
Yes,
of
sir.
July 30th, your testimony is that he was still out of compliance.
Yes, sir.
I just want to ask real quick, do you remember me calling you on July 30th?
Yes.
Yes, and
You called me that afternoon after I posted your property that morning.
and I'd said, hey, was everything
You
in
said
compliance?
you
And
were-
you said yes.
Yes.
So you just said yes, that everything was in compliance on the 30th when you posted it. You just agreed to that.
I don't remember, to be honest.
I'm
I'm trying
And
to
that's
think.
that's why
That's
I'm asking
okay.
you I'm asking you to testify what you know, not what you think.
Okay. Well, I know on July 30th when I posted it, I think I come back out there. I don't remember, to be honest. I know he wasn't in compliance when I did the first statement of violation notice of hearing. And then when he called me that afternoon, I think I went back out there and I said, yes, you are in compliance now. When I went back out there, but when I posted it, he wasn't. When I went back out there and I told him, then yes, you were in compliance. I have to go back
I
and
can
check.
show you video evidence of it being all fixed on the 29th, the day before she posted it.
Is it
No,
something
sir.
that you're able to submit to the
Yes,
city?
sir.
Because if you show me, we have to keep it for the record of the case.
That's fine.
So is it something, Clay, can you give me your email address?
They have
Or
it on my business card.
IT's email
Would
address?
you mind me just
Business
showing you, so
card.
for instance, real quick, so you
No,
can just see it?
I wanted the city to have it first in case
Yeah.
there's, so
No
we make
worries.
sure we maintain the record first.
Would you know? The council, saying that, like, okay, I see it. I also have a phone call record showing that we only spoke once that day, so she did not call me back. That I can also put into evidence.
July 12th was the day he was supposed to be in compliance,
Okay.
July 12th.
And
Photos on the 15th.
you arrive
Right,
at July
right.
12th as a compliance date. Walk me through the process of getting there. I think I know,
Yes.
but I want to hear it from you.
Sorry.
How do you arrive at July 12th as the compliance date?
It was after the notice of violation with the new date. I went back out there on July 12th and re-inspected. He was not in compliance.
No,
I
no,
took-
no, 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 that's, I'm asking a different question to that. So you say the compliance date for the July 1 notice of violation is July 12th.
Yes, sir.
And you arrive at that being the compliance date for the July 1 notice.
Yes,
Walk me through the math that you're doing.
yes. And then that's when on
Walk me
July,
through the math.
Go back to the beginning. Just go back to the beginning.
what do you mean to the beginning?
Your narrative.
Right here.
Go right ahead.
Okay, on July 1st, a notice violation with a new date was sent to the owner. So on July 12th is when I re-inspected.
Right, you re-inspected on July 12th. What
This
was
is
the
no-
compliance date of your letter?
What's the compliance date from this notice? That's what he's asking.
The compliance date was the 12th.
And how do you arrive at the compliance date being the 12th?
Is it in your
I,
notice?
I gave it 10 days,
10 days from what?
July 1st. 10 days or 7. Let me look and
Yeah,
see.
find the language in your notice.
Get your notice out.
Um,
What's the notice from? July 1st notice. Here.
I gave him 7 working days from July 1st.
From what date?
July 1st.
From what date? Read the rest of that sentence.
Read the sentence for the. magistrate.
Just both. You don't have to read it out loud to me. I want both of you to read it together, and
Where's
then
your seven?
because I think
7
that's what
working
Corrected
days.
within 7 working days. to
of
prevent
of
Working, it just says 7 working days to prevent further code
From
enforcement
July
proceedings.
1st.
So I'm looking. Where are you looking that I'm looking?
On my notice violation for July 1st.
So this I see violation to be corrected within 7 working days from receipt of the notice.
Oh, I see. He's.
What date was the notice received?
It was, I posted that second one.
What date was the notice received?
This
Is this
notice.
his stuff?
Yes.
Okay.
I'm looking here.
I'm gonna let Jack review
July
it before I
1st,
look
so-
at it.
Posted it. A notice violation when the new date was sent to the owner
I believe he only sent the picture.
and posted.
Did you track this when this was received or signed for?
That one wasn't to be signed, so that was up. Keep going. Yeah, that's the one I posted. I posted a notice violation,
What date was the notice of violation posted?
What date did you post? that?
July 1st.
Okay, so it was also posted
Do
on
I
July
have-
1.
Follow along. My apologies.
Let me see if I got
Go back to
July
your- go back
1st.
to your- Go back to your.
I'm looking. July. Notice violation.
Go back to your slideshow. You walk it right through. You got it in your slideshow.
Mhm. July 28th is when we inspection. July 28th, I took 2 photos.
Pause on this photo, and can I get Jack? You and
There's the 2
can y'all
photos.
let me get the respondent at the podium
Oh,
here for
sure.
a second. 'Cause I want to go back to the truck photo though, the June 28th truck photo. Respondent, I have a question for respondent on this. So I'm looking at a photo here of the truck on June 28th, 2024.
Yep.
Is this where the truck was on June 28th, 2024?
28, 24. I'd have to double check. I'm not 100% sure.
All right, so it's I'm trying to understand your test. So your testimony is that it was gone by June 30th.
Oh, it was moved on I had just sent evidence on the 29th. I'm looking back further to see if there's anything else. That's just what my app
Okay.
loaded first. Sorry.
Okay, that's okay. Do you agree though that it was there on the 28th?
I'd have to look at my thing. I'm not 100% sure.
Well, do what you need to do to see what you believe was there on the 28th. But I'm looking at a photo date stamped June 28th that's showing the pickup truck. And June 28th would have been after the compliance date.
I have photo right here of it in my property on the 28th that I can enter into evidence.
But is it your property where the truck is located or some other portion of your property?
It's behind my privacy fence. Not there.
I
Not where
wouldn't-
that photo is.
I wouldn't be able to see it behind his privacy fence. That, I can't tell if that's in the back by the alley or if that was on the side.
What about on June 27th? Where was the
Uh,
truck on June 27th?
I'm not 100% sure. I'd have to continue
Yeah,
to look.
keep
but
looking.
I just got a
Mhm.
thing. But just to answer the question, so because she's not able to tell, I can tell that's in my side yard on 15th. That's not in the back
So
alleyway.
that's not behind your fence.
That's not behind my back of my property. No.
I've got here too, where I took 2 more photos on the 12th showing. Right there is July 12th. That's the truck. That's after the 28th. There's another one on the 12th. Right there. The light bulb shows it was still in violation.
I apologize. The Nest app does not like to work without Wi-Fi.
It's okay.
I was able to send over the photo that I had.
I saw.
Well, I sent.
I haven't seen the photos yet, but I saw that they came through.
Yeah, I also sent the second one showing that on that date it is also behind in my property.
On which
behind my
date?
fence. The date that is on the photo, not that one, the one that was previously
On July 28th.
on 28th and 29th and the 30th, all behind.
How about the 27th?
I'm still scrolling.
When was the pickup truck put behind the privacy fence?
I'm not 100% sure. After I got back from July 4th, I was out of state. I came back and I think I had time to work on it around the 14th.
When did you get back into town?
From 4th of July, I was working in Georgia. I came back the 11th.
Did you see the notice of violation posted on your property when you got back home?
No,
When
I
did you
only
see
saw the
it?
second one. I only got the second one. She said there was one out there before, but I only got the second one, the corrected one.
The corrected notice of hearing.
The one that she put in my
Oh, the
yard.
stick in the ground.
Yep. I got told by a neighbor that there was one out there prior. That's why I'd called her. So there's someone that stated there was one, but I never saw it. It wasn't on my property when I got back. There was a metal stick, 100%. She probably put something out there. I'd have to go through a lot of footage to confirm that. I'm not trying to say she didn't do her job or
No, I
put that
understood.
in there.
No,
I'm just saying I tried to come to
I'm
compliance
okay
as
with
soon
that.
as I could. I was in compliance before she reposted my property, and I have photo evidence of that.
31st.
All I'm asking from you is obviously I need to pay fees. I just don't want this to be something where it could be used as a repeat offense. If I need to pay for the magistrate's time, I have no problem doing that. I'm just asking for this to, I don't know what the problem.
Well, let me ask you this. Why are you so concerned about a repeat offense?
Because I am gone, right? And I have plates stolen. I do not want a vehicle out there that is gone. That's something else that I have. I have a Miata that a plate was stolen. And that might be something she was alluding to earlier that she was going to bring the fact that you were saying.
Several vehicles. It's over the years, we have wrote him several times and gave him several
It's okay.
chances.
It's okay. I'm just ruling on the case before me today. So this is green card certified mail receipt from 6/17/2024. As is typical with green card receipts, I can't recognize signature. Sir, can you recognize the signature on it? Yes, absolutely. It's okay.
But I need to
You have to
go.
be formal.
The 16th,
I
yes.
didn't go out
Whose
there
signature is
in
that?
the afternoon. I went the
That
31st.
is mine.
And he was in
My
compliance.
signature.
So you received a notice of violation
Right.
in June that said you had 7 days to cure the violation,
That was the first one, and I moved the vehicle.
but then it came back.
Yeah, it's my property. I need to have it there. It's being repaired, but it's operable. And I have a dealer's plate, which I can also add in. That you
And
can
it
put-
was not in the vehicle.
Correct, and I'm not disagreeing with that. It's just what it is on the
You
road.
need to be on the mic,
Oh, so
sorry.
Yeah,
That's
sorry.
That's why I
Yeah,
asked.
she just needs you on the mic. So
No,
picks
yeah,
up.
no worries at all.
Yeah, no, you're okay.
Anytime it moves, a plate is put on the vehicle because, obviously I don't want to get a ticket for operating a vehicle without registration.
If I may, Mr. Magistrate.
No, my turn. So I'm reading you from the June notice of violation. If the violations are corrected and then recur, or if the violations are not corrected by the time specified, this case may be presented to the special magistrate. You received notice in June that you're in violation. You're telling me that you cured it. You're also telling me that you allowed it to fall into violation again. You are appropriately before me today.
Yes, sir. I'm not disagreeing with you at all. I fixed the problem. It was moved from that property. It was being worked on and it came back. And I thought that by putting it in a different location, it was not going to cause that issue. But you asked me not to make that argument. So I'm just letting you know my train of thought. I'm not, again, I don't know,
I understand. Since he went to the effort to get it to you, would you mind showing Jack
Sure.
on your phone what the respondent has sent, and just to make sure you don't have any objections before I look at it? This is what the respondent
I
submitted.
don't know what it is.
I know, that's why I want you to look at it before I look at it. See if you have any objections.
There's 2 emails, that's one of them. Let me get you the other. That's okay.
This is the other picture,
Mhm.
just back here at the back.
Yeah, and here they are printed.
The top part of those photos are what I was trying to specify, not just the bottom section. The top was actually showing the vehicle behind the fence with a date as well.
I guess I don't have an objection to you considering those. There's no way for us to verify exactly what that depicts or what it depicts as the subject of the hearing.
It is a gray F-150 that is in my possession and registered to me.
What part are you telling me is not showing?
This right here.
The top part, the main part that I was trying to show the date and time where it just clearly shows the truck.
And then
Okay.
here's this. Just the dates right there as well.
When was the pool removed?
Prior to that, sir.
What date was the pool removed? As best of your recollection.
Best of
what
my
date?
ability when I came back from July when I flew in, I think around the 13th or the 14th. But it was already starting to be done. I'd already drained it, which you can see in the photos that she had taken. You can see the first photo where it's swollen with water in it. And the second photo that she has is where it's drained. I was starting the process to remove it. And that was actually one of the times when I had called to ask right here. You can see it's actually behind you on 24.
It's on my screen too. That's
Oh,
why
okay,
I don't have a screen here. I don't turn around and look because I have a screen in
That
front
makes
of
a
me.
lot of sense. Saves you with the chiropractor.
And the pool was down in July, you say?
Yes, sir.
But you got the notice of violation June 17th or thereabout.
I got a notice after the pool was down. That's actually one of my phone calls. I got a notice.
I just showed you the green card receipt that you signed for. That you
Yeah,
told me
yeah,
was
that's
your
what I'm saying. That's
signature.
one of my phone calls to her was I got a notice saying my pool was still up when it was already removed.
Oh, I see.
Yeah.
But you're telling me you removed the pool in July.
Did you say June or July? I'm so sorry.
I said July.
Oh, I'm so sorry.
I thought you said you removed the pool after you got back from July 4th.
July. Yes, sir. I'm so sorry.
Okay, and so you received a notice of violation in June, and that's why I was verifying that notice of violation included the pool in it, because the very first one you got did not, but the one in June did, and this is the notice of violation that I just showed you, the green card that you confirmed that was your signature.
Yes, sir.
So you received this notice in June.
Yes, sir.
So you did not comply within the 7 days you were allowed to comply.
No, sir. I started draining the pool, as you can see in the thing.
Okay.
Yep. Unfortunately, I couldn't tear it down, and I did not have time to go through that process. I get called out for work a lot. I'm not home hardly ever. I have to pay someone to do my lawn to just stay within compliance with the city.
Well, that one is
Anything else from city?
Just to summarize it, the photos
Jack
show
needs to speak on that.
was met.
Call you want to shut the mic.
I'm sorry, just think that the photographs established that compliance wasn't met within the time specified. Property is now in compliance. It was confirmed as such at the end of July by Officer Neal, and city would just like a finding and recovery of costs within an appropriate time as deemed by the magistrate. That's all.
Okay. Any last word? Anything you'd like me to hear? Respond.
Yes, there was no photos taken, obviously, on the 30th from them. I provided photos on that date showing that it was in compliance. I apologize for, being, a little bit longer on it. I'm not trying to say it was done within the 7 days, but it was done within time before that notice was put in my yard.
Okay. So I'm fighting in favor of the city. I'll explain to everybody why. And so I am going to order that it was a violation. A future violation could be prosecuted as a repeat violation. I will order the repayment of costs in the amount of $298.69. How much time do you need to pay that? Normally I say 7 days, but I give people time on the cost.
At this time, I unfortunately do need extra
How
time.
much time?
I literally just had to, it's going to be a while. I have a family medical issue
How
in
is
Michigan.
60 days?
60 days is doable. I appreciate it.
Is 90 days better than
It's
60?
90 for 200 something. It's not going to be that
Okay,
drastic.
now I'm
The
gonna say 60
would be
on that.
nice.
Let me explain my rationale to everybody, including myself, so I can take notes and get this down so I can get it all into the written order. I do not know what was there. I mean, there's conflicting testimony as to what was there on the 30th. And I think to the respondent's point, the absence of a photograph city was in the best place to prevent that lack of knowledge on the 30th. However, the green card for the June notice is telling in conjunction with your testimony. Because you heard me say earlier, I'm going to rely on the last notice of violation, which would be the July. But what you also told me is you didn't get that until you'd already fixed everything. So that means I have to rely on the next to last notice, which was June, the one that you admit to having gotten. You didn't tell me, you told me you didn't get the July one. So you didn't know that she'd given you more time. So the evidence that I'm relying on is you did not comply with the June notice, which is the only notice you testified to having done anything about. You were aware of the violation because of the June notice. You testified to me you did not receive the July notice until you had already fixed everything.
Right, but the city had given that time, even if I was unaware. She's also not providing evidence that it wasn't fixed on the 30th before posting.
But you had no idea that they'd given you more time.
I fixed it even without that.
But you did not fix it in time of the notice that you were aware of. And that's why I'm ruling the way that I'm ruling. Because you got a notice, and don't get me wrong, I understand life creates other situations and we have to prioritize. I don't fault you for it, but I have to apply the law. And even if there were other things that were more important, and I'm not questioning whether or not they were more important, this fell by the wayside because of it. And this is the consequence of that.
So I just want to clarify, even though the city had given me extra time, this magistrate is not viewing that as the time that was supposed to be given.
Correct. No, I'm not implying it because you were telling me you did not know you had been given it. So the only notice of violation you were testifying to have been aware of was June.
And July 30th.
Right. You
after.
became aware of that after.
Correct.
You reacted to the June notice and you did not react in time.
Okay. I appreciate your time.
Yes, sir. I appreciate yours. I appreciate your demeanor today. I really do. I know this is not the result you wanted. I think it is the right result.
Is there anything else that could be done in this ruling?
What do you mean?
Later, a date to review?
What do you mean a date to review?
I don't know. I don't know. Because
If you would like to appeal my ruling, you can do that to circuit court.
Okay, I appreciate that's all I was saying.
Yeah,
I have
appeal,
no idea
appeal
how
of my
any this
decision
works.
is to circuit court.
Okay, perfect. I appreciate it.
Okay.
Thank you.
Thank you. Okay, I'm ready for next case.
Case number 2024-521, Eugene Edward Harlow, RLE, owner, location of violation 4918 Cul-de-sac Court, St. Cloud, Florida.
Good afternoon, Melissa House, Code Enforcement Officer for the City of St. Cloud. At this time, I would like to enter into evidence the following items: a copy of the notice of violation or courtesy notice of violation, copy of the notice of violation sent by regular mail, copy of the notice of violation sent by certified mail, copy of the notice of violation posted on the property in City Hall, copy of the statement of violation and notice of hearing sent by certified mail posted on the property and City Hall, copy of the PowerPoint presentation, affidavits of postings, evidence of mailings, the code sections in violation of, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $251.96. The respondent is not here.
Thank you.
On March 7th, 2024, after receiving a list of business licenses, delinquent business licenses, this location did not renew their business tax receipt or certificate of use license. I sent an email to the business to see if compliance could be met prior to issuing any notices. On April the 8th, the city's computers had been down for over 2 weeks, so no renewals would have been accepted. I checked again on April 23rd, and the licenses had not been renewed. I sent out a courtesy notice of violation to the owner of the property, who is also the owner of the business, to correct these violations within 10 working days. On May 8th, the licenses were still delinquent. I sent out a notice of violation by regular mail. On May 28th, the licenses were still delinquent. I then sent out a notice of violation by certified mail. On June 17th, I called the number on file as a last attempt to obtain compliance prior to scheduling to the special magistrate and left a message with no response. The certified mailing was not signed for. It was returned. So I will be posting the property with a notice of violation. On June 20th, I received no response to my phone message. I created that notice of violation, posted it on the property and City Hall, did an affidavit of posting, and took one photo of the posting. On July 8th, the business tax receipt and certificate of use had not been renewed. On July 10th, I sent out a statement of violation and notice of hearing for today's magistrate hearing, posted the properties and City Hall, did an affidavit of posting, and took one photo. On July 22nd, and again today, the licenses are still delinquent and the owner has not reached out to me. It is the city's recommendation that the respondent be found in violation of allowing a business to operate with a delinquent business tax receipt and certificate of use license at this location by the time specified. The city would also recommend the respondent be given until September 5th, 2024 to come into compliance or pay a fine in the amount of $100 a day until compliance is met. The city would also request the cost incurred in bringing this case before the magistrate in the amount of $251.96 be paid within 7 days of the written order by the special magistrate. And that concludes my presentation.
I see returned mail in the packet. Did anything get received or was it all returned?
I don't think did the statement of violation one come back yet? Let me see. I was out for 3 weeks, so, yeah, the statement of violation one said unclaimed,
Okay, so everything you've mailed to the property has come
has
back.
come back as unclaimed.
Was there
So
any
they-
regular mail sent to property that has not come back?
No.
And what evidence do we have that there is a business being operated from the?
They are active in the corporation, on the corporation website, on Sunbiz.
Okay, and this is the address listed for that.
This is the address listed.
That's what I needed. And the reason why that returned mail, again, I mentioned at the last of the hearings when we had a
Mhm.
business tax receipt is, I understand the code enforcement's position that they're supposed to notify code enforcement if they shut down the business. Sometimes they don't. But the reason why the returned envelopes is I do want to make sure that they are there. But if they're
Mhm.
registered to Sunbiz, then this at the very least should prompt them to change their registration.
I think there was even, there's two different vehicles. Even every time I posted the property, nobody would come to the door. I mean, you try and just get them to even just close them out if you're not in business. But because from my understanding, the planning department has told us that it doesn't matter what Sunbiz says now. If they say they're out of business, they're closing the licenses out. So, because that's up to them to get with the corporation. So if they would just reach out and say, hey, I'm not in business or whatever, but I mean, I've been trying since March.
Based on the evidence testimony received, I find in favor of the city, find the respondent was in violation for allowing a business to operate without business tax receipt or certificate of use license, require the respondent to come into compliance by September 5th, 2024. If not brought into compliance by that date, a fine in the amount of $100 per day to run until compliance is met. We'll also order the respondent to pay the administrative costs incurred by the city in the amount of $251.96. That amount will be due within 7 days from the date of my written order.
Thank you, sir.
Case number 2024-868, RS Rental 2 LLC, owner, location of violation, 1656 Cypress Wood Circle, St. Cloud, Florida.
Good afternoon, April Bennett, Code Enforcement Officer. I'm presenting this case for the property located at 1656 Cypress Wood Circle. At this time, I'd like to enter into evidence the following items: copy of the courtesy notice sent by regular mail to the owner of record and the registered agent, Copy of the notice of violation sent by certified mail to the owner of record and the registered agent. Copy of the statement of violation and notice of hearing sent by certified mail to the owner of record and registered agent posted on the property in City Hall. Copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code section in violation of, copy of the original deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $241, and they are not here. On May 15th, after receiving a complaint about a tree branch from this location that was hanging low over the sidewalk, I completed an inspection at this location and was able to verify that complaint. On May 17th, while doing the research to write up this case, I was able to verify that this location is a rental property and there was not a landlord business tax receipt on record. I sent out a courtesy notice by regular mail to the owner of record and the registered agent. On May 31st, a re-inspection was completed and I was able to verify that the tree at this location was trimmed, which cured that violation. However, I was able to verify that there was still not a landlord business tax receipt on record for the property. On June 3rd, I sent out an email to Renew Management advising that this address could be added as an additional site to an existing BTR that they had on record. They were provided with the landlord business tax receipt application and instructions on how to submit. On June 10th, I sent a follow-up email advising that the application had not been submitted. I received a response from that email stating that Renew Management was no longer the management company for that location, and I was to now send it to Darwin Homes. I was instructed to send emails from Darwin Homes to Adore Property Management. I forwarded the email chain to the email address that was provided for Adore Property Management. On July 2nd, I was able to verify that there was not a landlord business tax receipt on record for the property. On July 3rd, I sent a notice of violation by certified mail to the owner of record and the registered agent. On July 22nd, I was able to verify that there still was not a landlord business tax receipt on record for the property. On July 30th, I sent an email to Darwin Homes advising that I had not received the landlord business tax receipt application for the property. I received a call from Darwin Homes stating that their records show that this property was now managed by Pagaya Homes. Darwin then forwarded the email chain to Pagaya. On August 9th, I sent out a statement of violation and notice of hearing by certified mail to the owner of record and the registered agent, posted the property and City Hall, did an affidavit of posting, and one photo was taken. On August 15th and again on August 21st, I was able to verify that there is not a landlord business tax receipt on record for this property. It is the city's recommendation the respondent be found in violation of allowing a landlord business tax receipt to not be obtained for this property and not corrected by the time specified. The city would recommend the respondent be given until August 30th to obtain the business tax receipt, or a fine in the amount of $250 a day be assessed until compliance is met. The city would also request that the cost incurred in bringing this case before the magistrate in the amount of $241 to be paid within 7 days of the written order by the special magistrate. And that concludes my presentation.
Based on the evidence testimony received, I find in favor of the city, find the respondent wasn't or is in violation for allowing the property to be rented without landlord business tax receipt. Allow the respondent until August 30th, 2024 to obtain that business tax receipt if not brought into compliance by that date. Is there any safety hazard? Is there anything? I'm going to do the same as this case as the last one and go to $100 a day if not brought into compliance, rather than the $250 that's been requested. Also order the respondent to pay the administrative costs in the amount of $241. That amount will be due within 7 days from the date of my written order.
Thank you.
Case number 2024-869, 2017-1 IH Bar LP owner, location of violation 1604 Cypress Woods Circle, St. Cloud, Florida.
Good afternoon, April Bennett, Code Enforcement Officer. I'm presenting this case for the property located at 1604 Cypress Woods Circle. At this time, I would like to enter into evidence the following items: copy of the courtesy notice sent by regular mail to the owner of record and the registered agent, copy of the notice of violation sent by certified mail to the owner of record and the registered agent, Copy of the statement of violation and notice of hearing sent by certified mail to the owner of record and registered agent posted on the property and City Hall. Copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code section in violation of, copy of the original deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $243. And they are not here. On May 15th, after receiving a complaint about a tree branch from this location hanging low over the sidewalk, I completed an inspection at this location and was able to verify that complaint. On May 17th, while doing the research to write up this case, I was able to verify that this location is a rental property and there was not a landlord business tax receipt on record. I sent out a courtesy notice by regular mail to the owner of record and the registered agent. On May 31st, a reinspection was completed and I was able to verify that the tree at this location had been trimmed, which cured that violation. However, I was able to verify that there still was not a landlord business tax receipt on record for the property. On July 2nd, I was able to verify that there was still not a landlord business tax receipt on record for the property. I sent out a notice of violation by certified mail to the owner of record and the registered agent. On July 22nd, and again, on August 7th, I was able to verify that there still was not a landlord business tax receipt on file for the property. On August 9th, I sent out a statement of violation and notice of hearing by certified mail to the owner of record and the registered agent, posted the property and City Hall, completed an affidavit of posting, and one photo was taken. On August 15th and again on August 21st, I was able to verify that there is not a landlord business tax receipt on record for this property. It is the city's recommendation the respondent be found in violation of allowing a landlord business tax receipt to not be obtained for the property and not corrected by the time specified. The city would recommend the respondent be given until August 30th to obtain the BTR, or a fine in the amount of $250 a day be assessed until compliance is met. The city would also request the cost incurred in bringing this case before the magistrate in the amount of $243 to be paid within 7 days of the written order by the special magistrate. And that concludes my presentation.
Is the residence occupied?
No.
Why do they have to have a rental permit?
It's a rental property. It's listed as for rent. It just, there's not an occupant at this second, but it is an investment, a rental property through
What
the
does the
IH
code
borrower.
say?
I have here, section 40-162 reads, any person or entity owning property within the city limits of St. Cloud who rents or leases said property shall obtain a local business tax receipt. Local business tax fee will be assessed by property owner.
And how does the code define what it means to rent or lease? Does it include holding out as?
Well, that would be our position, of course, that the code would.
But does the code actually say it?
In the section I've read to you, I've read it verbatim as to how it reads.
No, I know. Does it in the definition section? Does it say elsewhere that rental is defined as to include holding out? Because I read this more narrowly than the city does. I read this to mean if you rent it or lease it, you have to have a tenant. But until you find that tenant, or you have to have a license. Until you find that tenant, you don't. I thought of the question looking at the photograph and see it looked like an unoccupied structure. Was the prior case occupied?
Yes.
Okay.
This one is just recently unoccupied. They've had it's been a rental property for a couple of years without a license on it, and it's up for
When was
rent
when
again.
is the last time you were aware that it was being rented?
A neighbor told me that the current
When's the last time you have
tenants-
personal knowledge that it was being rented?
Personal knowledge, I don't. A
Okay.
neighbor told me it had just they had just recently moved out about a month ago, and that's why it was sitting empty.
Unfortunately, I can hear it, but I can't rely on hearsay testimony.
That's fine.
I can allude to analogous language in the Land Development Code under short-term rental talks about available for use, which I would submit is consistent with the code here.
Can you give me that code section? I'm
That is on the definitional section of the Land Development Code under short-term rental, stating any dwelling or portion thereof that is available for use or is used for accommodations or lodging of guests paying a fee or other compensation for a period of less than 30 days, et cetera. But that's included in the definition, which I would submit would
yeah, that's
be
kind of what I was looking for. Is,
consistent.
yeah, definition that gets you there. That's what I wanted to see. You said that's 8.2.2.
No, sir. I'm sorry. That's the Land Development Code definitional section for short-term rental.
Oh, it's not in the general
It's
definition.
not in the general definition of rental. There is in my code no specific rental definition in my code definition list, but I do have a short-term rental language which talks about available for use, which I would submit would be consistent with the intent of the code in this section.
Okay, and I will accept that argument, and based on that, I'll find it because they're holding it out as a rental, and based on the definition, find that it is appropriate to extend that definition to apply here, and find that they are in violation for holding it out for rental without having first obtained the rental permit. Order them to come into compliance by August 30th, 2024. If not brought into compliance by that date, to fine the amount of $100 per day. We'll order them to pay the administrative costs incurred by the city in the amount of $243. That amount due within 7 days from the date of my written order.
Thank you.
Case number
Give me 1
20,
minute. Let me write down a
Sorry.
note before I lose it, the thought. Okay, you can go. Thank you.
case number 2024-870 IH6 Property Florida LP owner location of violation 2303 Sweetwater Boulevard, St. Cloud, Florida.
Good afternoon, April Bennett, Code Enforcement Officer. I'm presenting this case for the property located at 2303 Sweetwater Boulevard. At this time, I'd like to enter into evidence the following items. Copy of the courtesy notice sent by regular mail to the owner of record and the tenant. Copy of the notice of violation sent by regular mail to the owner and the tenant. Copy of the notice of the violation sent by regular mail, certified mail to the owner of record, the tenant, and the registered agent. Copy of the statement of violation and notice of hearing sent by certified mail to the owner of record and the registered agent posted on the property in City Hall. Copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code section in violation of, copy of the original deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $252.88, and they are not here. On May 17th, after receiving a complaint about an abandoned vehicle at this location, an inspection was completed, and I observed that there was a silver Dodge pickup truck without a registration tag at this location. One photo was taken. On May 20th, while doing research to write at this case, I was able to verify that this location is a rental property, and there was not a landlord business tax receipt on record. I sent out a courtesy notice by regular mail to the owner of record and the tenant. On June 3rd, a reinspection was completed, and I was able to verify that the Dodge truck did not have a current registration tag, and there was still not a landlord business tax receipt on record for this property. One photo was taken. On June 7th, I sent out a notice of violation by regular mail to the owner of record and the tenant. I also sent the notice of violation by email to Invitation Homes. On July 1st, reinspection was completed, and I was able to verify that the Dodge truck still did not have a current registration tag, and there was not a landlord business tax receipt on file for the property. One photo was taken. On July 2nd, I sent out a notice of violation by certified mail to the owner of record, the registered agent, and the tenant. On July 31st, a reinspection was completed. I was able to verify that the Dodge pickup truck was removed from the property, which cured that violation. However, there was still not a landlord business tax receipt on record for the property. On August 9th, I sent out a statement of violation notice of hearing by certified mail to the owner of record and the registered agent, posted the property and City Hall, completed an affidavit of posting, and one photo was taken. On August 12th, I received a call from a representative of Invitation Homes. She had called about a different case. However, I provided her with the information about this property as well. She was emailed the landlord business tax receipt application packet and was given the information on how to submit. On August 15th and again on August 21st, I was able to verify that there was not a landlord business tax receipt on record for this property. It is the city's recommendation that the respondent be found in violation of allowing a landlord business tax receipt to not be obtained for this property and not corrected by the time specified. The city would recommend that the respondent be given until August 30th to obtain the BTR, or a fine in the amount of $250 a day be assessed until compliance is met. The city would also request the cost incurred in bringing this case before the magistrate in the amount of $252.88 to be paid within 7 days of the written order of the special magistrate. And that concludes my presentation.
Based on the evidence testimony received, I find in favor of the city, find that the respondent is in violation for allowing the property to be rented without a proper landlord business tax receipt. Order the violation to be cured by August 30th, 2024. If not brought into compliance by that date, a fine of $100 a day will be imposed until compliance is met. Also order the respondent to pay the administrative costs incurred by the city in the amount of $252.88, which amount will be due within 7 days from the date of my written order.
Thank you.
Case number 2024-1061, Doris Russo, owner, location violation, 1019 Georgia Avenue, St. Cloud, Florida.
One of our not a repeat case. I want to repeat respondents, yes?
It could have been, but no, we're not taking it as a repeat.
Okay. No, I see that it's not a repeat. I just was commenting on it's a respondent that I've seen before.
Yes. Good afternoon, Alex Miller, Code Enforcement Officer for the City of St. Cloud. At this time, I would like to enter into evidence the following items: copy of the notice of violation sent by regular mail, copy of the notice of violation sent by certified mail posted at the property in City Hall, copy of the statement of violation and notice of hearing sent by certified mail posted at the property in City Hall, copy of the PowerPoint presentation, affidavits of postings, evidence of mailings, copy of the section in violation, a copy of the deed to the property, and a copy of the cost incurred if the magistrate found the respondent in violation in the amount of $281.96. And the respondent is not here. On July 19, 2024, Officer House received a complaint about this property having high grass. Upon arrival, Officer House verified that the grass was high, and she also observed an accumulation of solid waste debris at this location. A notice of violation by regular mail was sent to the owner and the tenant to correct the violation, and 3 photos were taken. On August 1st, I verified that the violations were not corrected. 6 photos were taken. On August 2nd, a notice of violation by certified mail was sent to the owner and the tenant to correct the violations. While posting the property, I was able to speak with the owner and explain the violations that she will need to correct. She understood and stated that she will be hiring somebody to cut the grass and clean the property. Posted the property in City Hall, an affidavit of posting was created, and 1 photo of the posting was taken. On August 9, I verified that the property was still in violation. A statement of violation and notice of hearing was sent by certified mail to the owner and a copy to the tenant. Posted the property in City Hall, an affidavit of posting was created, and 7 photos were taken. On August 9th, I verified that the property was still in violation. A statement of violation and notice of hearing was sent by certified mail to the owner and a copy to the tenant. Posted the property in City Hall, an affidavit of posting was created, and 1 photo was taken. Sorry, On August 16, I verified that the accumulation of the solid waste debris violation was still not corrected. The grass was mowed, but the property was still in violation. Sorry. On August 21, I verified that the property is not in compliance, and it is the city's recommendation that the respondent be found in violation of allowing an accumulation of solid waste debris and allowing the grass to be over the height of 8 inches not corrected by the time specified. The city will also request that the cost incurred in bringing this case before the magistrate in the amount of $281.96 to be paid within 7 days of the written order by the special magistrate.
Okay. Based on the evidence testimony received, I find in favor of the city, find that the respondent is in violation. As stated in the notice of violation, order the respondent to cure the violation on or before August 30th, 2024. If not brought into compliance by that date, I am going to impose the $250 requested. That grass is already high, and another week it will be nuisance high. I also order the respondent to pay the administrative cost in the amount of $281.96. I am going to extend the time on that from what I usually do. I'm going to give her 30 days because to the extent she's spending money right now, I want her to pay.
She's in compliance now, sir.
Oh, she's in compliance.
She's in compliance with everything.
Oh,
Sorry. Yeah, she's in compliance now with everything. She's removed. This, I'll show you,
so you just need finding a fact and
Yes.
imposition of cost. And
Thank you,
I am
sir.
going to give her more time though, just because she's been here before and I know she
Yes.
has issues. So that will help. So I'm gonna give her 30 days to pay the cost.
Yes, sir.
So you do not need order to come into compliance.
No.
You just need finding a fact and entry of administrative cost in the amount of $281.96. That amount to be paid within 30 days of the date of my order.
Yes, sir.
That is it on that case.
Thank you.
Unfinished business, none. New business, Jack will be discussing this.
Just an update, if I could, for you, Mr. Magistrate. The city council earlier in August approved an ordinance implementing a school zone speed enforcement program through the use of cameras. I'm sure you probably were alerted to this. I provided you a copy of the relevant statute, but if a violation occurs, the owner of the car will be sent a citation, has the opportunity to appeal the citation. The statute and the ordinance provide that the appeal will be heard by the code enforcement special magistrate. And so we think that you'll start to see cases maybe as soon as next month, but
Okay.
in the next couple of months probably, but just to make you aware of it. I didn't provide you a copy of the ordinance, but I did provide you with a copy of 316.1896, which has the processes of
Okay.
and so forth. So anyway, that was it.
When we have a hearing, if we could have a copy of the ordinance, just so I can refer to it in case I need it. Yeah, just so I have, before we have a hearing on one, just so I can make sure I'm familiar with it before,
Yes, indeed.
with the city code.
Yes, indeed.
Anything else from,
No, that was all.
I have one thing. So for everyone, I don't want to talk specifically about the case since the respondent is gone, but generally, it worked to the city's benefit today because that is why I ruled the way that I did on that case, because the notice of violation says that you have until X number of days from date of receipt. And it was the question as testimony, I didn't receive the last one until after. That's why I ruled the way that I did on that case. But it's the first time that we've had a case that really had a reason to think about that actual date that the clock starts to run. And as those notices are worded, the clock starts to run on the date they receive it. And if, as today, we have a respondent who says, I didn't get it, for whatever reason that is, I was out of town for a month, I didn't get it, that could create issues. So y'all might want to take a look at that and see if you want to use some other trigger other than date of receipt. Again, it worked to your benefit today, but I can imagine other cases where it could make, as complicated as today was, it could get complicated quickly if I have a respondent who's saying, never got it. I was out of town, and even the posting, because I know that's where code enforcement was going on that case. It was posted. That's a form of receipt. I was out of town that month. I didn't get back until a month later, and somebody had pulled it off my lawn by then. So there's a lot of questions that receipt injects, and so y'all might want to take a look at that and think of, do you want to reword those notes, your form notices? But that was it for me. With that, anything, clerk?
Next scheduled meeting, September 18, 2024.
We are adjourned. And once we're off the record, I have something else for you unrelated to St. Cloud. So once we're off the record, if somebody could give me a cue.